pleased to welcome you all, and certainly delighted to be joined today by Ernest Lima from XReg Consulting, who will be delivering a training session for us today. So first of all, thank you very much, Ernest, for being here. Ernest will be speaking on the fund legislative framework, giving us an oversight and a review of where we currently are. Hopefully it'll be a really good, insightful, technical discussion onto the review of the Act last year or the year before, I think it was already, and how we can navigate the legislative framework going forward. So I have already spoken to Ernest, and he's been very eager to point out that he's keen to see this be carried out as interactively as possible. So if whenever you want to raise a question, either please raise a question by raising your hand or submitting a question on the chat. I'll be actively moderating that as we go forward, and submitting your questions or passing over the mic to you as we proceed through the presentation. Just in terms of housekeeping, Ernest has indicated that he's got a presentation for us for about 30 to 40 minutes. So that should carry us through till about quarter to 20 to 11 this morning. We have Q&A throughout, so that may well extend it. So please don't be shy. Please submit your questions as we go forward, and we'll be happy to answer them as we proceed. Okay. So without further ado, I'd just like to hand over to Ernest to take us through his presentation and the training this morning. Thank you.
Thank you, Alan. Good morning, everyone. And thank you to GIFIA as well for having me. I think this is GIFIA's first training session of 2021, and I'll be talking about the funds legislation in Gibraltar and some of the recent changes to financial services laws generally as a result of the EU exit. Alan, do you want to put on the slides? Thank you. So as Alan mentioned, I'm very happy for this to be interactive. So as he said, unmute yourselves or raise your hand and ask any questions. I know it's a dry subject, it's legislation, but I'd be very happy to answer any questions as we go through it. So the purpose of this presentation is to provide you with an overview of the funds framework in Gibraltar, and which includes funds themselves and counterparties. And I'll also be talking about EU exit. So as a lot of you know, there's been many legislative changes over the last few years, and for my sins, I have been at the center of it all. The objective of this session is to take you through the relevant elements of financial services law in Gibraltar and regulations as they apply to funds and counterparties. I think this should serve as a good refresher of how the different pieces of legislation interact with one another. And I will also be reminding you of some of the main changes that came about through the LRP, which has been in force for over a year now. And I'll also be talking about the recent changes due to Brexit. So you can see the agenda on the slide. I'll be providing an overview of the funds framework. I'll be talking about the regulated activities as relevant to CISs, reminding you of the architecture of the FSA and how it's relevant to fund counterparties in particular. Then I'll be going through some of the key regulations that apply to this sector. I'll talk about regulated individuals and specifically what are the specific areas that you need to think about if you're in this sector. Briefly talk about the powers of the GFSE, and then I'll touch upon a couple of other parts of the Act that are relevant to everyone really, and finally I'll take you through the EU exit changes. Next slide, please. Thank you. So these are the key pieces of legislation as they apply to funds and counterparties. So the Financial Services Act 2019 is the framework piece of legislation, the overarching act that has all the high-level provisions relevant to all financial services, containing all the regulated activities, all the different powers, procedures, and I'll go through some of them a bit later on. And then you've got a few sets of regulations, which I'm going to be taking you through Today, you've got the usage regulations, the EIF regulations, AIFM regulations, depositories, and collective investment scheme administrators are regulations. Next slide, please. So in terms of the collective investment schemes, Part 18 of the Act is a specific part that deals with the high-level provisions around CISs and CIS counterparties. It sets out the procedure for authorization of UCITS and non-UCITS retail schemes, and also contains the high-level authorization requirements in the Act. There's also procedures for the recognition of foreign schemes. Until recently, there was also procedures for the recognition of EEA UCITS schemes, but that has fallen away as a result of the Brexit changes. So you will see, if you have a look at the Financial Services Act, you will see that there's quite a few sections and parts and schedules that have been omitted, mostly because of the recent changes that have been made as a result of a withdrawal from the EU. This part also contains the restrictions on promotion and the general prohibition. So essentially, the fact that no one can promote a fund in or from Gibraltar unless you're authorized or recognized. And of course, there are some exceptions. You can be a private scheme, you can be an EIF, and those are set out in the schedule. And it would be an offense if you promote without being authorized or recognized or exempt, and this is called the offense against the general prohibition. This part also sets out the regulatory powers that the GFSE has, so the power to refuse or authorization or recognition, the power to impose conditions. It also sets out the intervention powers, such as the power to issue directions, suspension of authorization, or recognition for that matter. It also has a few sanctioning powers. And what it does is that it cross-refers to the general part in the Act, which is Part 11, which sets out the sanctioning powers that are applicable for all sectors. And in this case, I would just note that there is a different fining limit depending on the type of activity and the type of CIS. And that is directive driven, and that hasn't changed as a result of Brexit. In relation to private schemes, you would have to look at Part 2 of Schedule 24 to the FSA. This sets out the requirements relevant to private schemes. And it points out that for example, the restriction on promotion wouldn't apply if you are promoting in accordance with the requirements in Schedule 24. And then there's the usage regulations, which I will talk a little bit about later, but essentially this is the piece of legislation that gives effect to the usage directives. It contains some supplemental authorization conditions for CISs. There are additional provisions around powers. There's the conduct of business and other general obligations of usage. The usage regs also contain requirements for counterparties, which I will cover later on. And finally, there's also the regulation making power for EIFs, and that regulation, the Minister has made the EIF regulations, which I will talk about later. So regulated activities, you will see on the right in the slide, the list of relevant regulated activities in this sector. There's quite a few. You've got the usage manager, depository, and further down the list, you've got the private scheme depositories, small scheme managers, etc. Section 5.1 and 5.2 of the Act define what is a regulated activity. So it defines it as a regulated activity is an activity of a specified kind, which has to be done by way of business relating to any of the items listed in section 5.2. And in this case, the relevant one would be 5.2J, which refers to property of any kind. A collective investment scheme would be a property of any kind. The regulated activities that are listed there on the slide are in paragraphs 93 to 102 of Schedule 2 to the Act. And it sets out the detail of what those regulated activities are. It also contains the exclusions that are relevant to particular regulated activities. And you should note that the architecture of the Act, which I'll be going through now, is applicable to all these regulated activities. So once you're doing a regulated activity and you're authorized, you get a permission from the GFSC, you become a regulated firm. And then therefore everything else, most things apply in the Act. Next slide, please. Thank you. So the architecture, some of you have probably heard this before. I've done a couple of presentations whilst I was at the FSC and post after I left around the architecture of the Act, and so this should serve as a good reminder. So this basically establishes like an umbrella system which has a single authorization process for this Act, whereas before you used to have different acts for different sectors. Now it all comes under the Financial Services Act, and there's three key parts. There's part 2, which sets out the regulated and prohibited activities. So I've already mentioned what a regulated activity is. This explains what it is. It lists the items to which they relate. So for example, deposits, contracts of insurance, property of any kind. And the detail is in Schedule 2 to the Act, which is over 100 pages because it covers the whole remit of the GFSC's the remit of the GFSC and all the regulated activities that they supervise. This part also includes the so the regulated activities. They detail what are excluded activities, which are the activities that can be carried out without requiring authorization. The part also covers the general prohibition. So like in the CIS part, which I mentioned earlier, this is a legal concept that no one can carry out a regulated activity without a permission or an exemption, and it would be a criminal offense if they do. This part also covers the restrictions on financial promotion. So it prevents unauthorized persons from communicating an invitation or an inducement to enter into or offer to enter into a financial services agreement, which would result in the carrying out of a regulated activity. So in order to maybe put into context and explain some of the regulated activity, some of the key terminology, in order to carry out a regulated activity, you must be an authorized person. If you're an authorized person, you become a regulated firm. You can also carry out a regulated activity if you are an exempt person. So for example, appointed representatives or tied agents. And some small firms that do not exceed a particular threshold, for example, such as small e-money firms, but they would still be required to comply with certain requirements, and maybe register with the GFSC, but would not need authorization as such. The next relevant part is part 6, which sets out the authorization and exemption provisions. It defines who can be an authorized person and the procedure for obtaining authorization. It also talks about the persons that carry out regulated activities in Gibraltar and the fact that they are authorized persons. Until recently, this included incoming EEA firms. That has fallen away as a result of Brexit. There are provisions around exempt persons, and there is a regulation making power for the minister to exempt persons in regulations, and that is what it's done. What has happened in certain cases. This linked to a schedule which used to set out all the details around passporting, but this has also gone, as you might imagine. It also contains provisions around authorized persons and the fact that they are now only regulated firms that apply for a permission, and part 7, which I'll go on to now. There were provisions here around EEA firms and the fact that they can qualify for authorization by satisfying either the establishment or the services conditions, but obviously this has also been removed. And finally, part 7, which is, I think this is where, as a result of the LRP, there were more changes than in the other ones. The other parts were more cosmetic, and here it introduces the fact that there is now one single permission that the GFSC will issue to be able to carry out one or more regulated activities, as opposed to before, where it used to be multiple licenses. So to obtain a permission, you have to satisfy the threshold conditions. So now there's a generic threshold conditions that apply to everyone, which is no real change to how it was done before, but it's more defined and it's clearer now in the legislation. So threshold conditions include things like the location of officers, the fact that you need to have appropriate financial and non-financial resources. You need to be capable of being effectively supervised by the GFSC, and so on. In the sector-specific regulations, there are some other specific threshold conditions for authorization, and those will be covered in the relevant sets of regulations for the different sectors. This part also includes the supervisory powers that the GFSC has, so the intervention powers that they would try and use to prevent any breaches of the legislation, so things like variation, cancellation, and imposition of requirements. This also sets out the procedure for when the GFSC is exercising the powers, so the warning, written notice procedure, the fact that you can make representations, then it would go to the decision-making committee or the GFSC if it issues a decision notice. It could go directly to appeals. Just to note that the GFSC has a power for directions to take effect immediately, but this can only be exercised in urgent cases. Next slide, please. Thank you. So I'm going to be talking a little bit about some specific regulations relating to the sector, the fund sector. So first of all, I've already briefly talked about the usage regulations. So this is the set of regulations which before used to be covered in a number of regulations. So now it's been consolidated into one. This is the piece of legislation that transposes all the previous usage directives into Gibraltar law. As I mentioned before, it supplements Part 18 of the Act in respect of the relevant CIS activities, such as management companies and usage depositories. And it also contains all the requirements for everyone, conduct of business, prudential, any additional regulatory powers. The passporting provisions have obviously fallen away. The next one is the AIFM regulations. So this is a piece of legislation that transposes AIFMD into Gibraltar law. It contains additional authorization conditions for in-scope AIFMs and the requirements for in-scope AIFMs. And then it also talks about and introduces the small AIFMs and the small scheme managers. And so small AIFMs, these are exempt persons, so these wouldn't require authorization under the Act, but they would need to register with the GFSC. So to distinguish them between the small scheme managers, small AIFMs are the self-managed small funds whose assets under management do not exceed a particular threshold, and that's set out in the AIFM regs. Whereas small scheme managers do require authorization, and they are small and external AIFMs, and so there's some threshold conditions and authorization conditions, and they would also need to comply with certain conduct and prudential requirements. But this is essentially a stepping stone regime to become a full scope AIFM in the future once you exceed certain thresholds, etc. But as I said before, to distinguish it between the small AIFMs are exempt and not authorized, whereas small scheme managers are. And then the AIFM regs also include the national private placement regime requirements and conditions. So the conditions around marketing of in Gibraltar of AIFs managed by small AIFMs. Small AIFMs in third countries, whereas before it used to be small AIFMs in EA states or third countries, and there were different provisions for both. Now there's only provisions in relation to small AIFMs in third countries. Next slide. Depositories, so the depositories regulations, it contains the requirements for depositories of funds. There are some additional authorization conditions specific to depositories. There are, I think I alluded to it before, there are some depository requirements, specific depository requirements for UCITS and AIFMs in regulations, in their respective regulations. And then you got the collective investment scheme administrators regulations, which I think were made specifically for EIFs. Contains the requirements for such administrators and some additional authorization conditions relevant to such entities. So EIFs, EIF regulations were changed before the LRP and post LRP. Really, there was some terminology and general alignment changes, but nothing really of substance. This set of regulations contains the requirements for EIFs generally. It defines an experienced investor and what are the provisions to qualify as an experienced investor. There are some authorization conditions and the procedure for authorization as an EIF. You also have the management and control of EIFs, so the need to be fit and proper, the need to be able to be supervised effectively by the GFSC, and etc. There are provisions around the appointment of an administrator, which could be one that is authorized by the GFSC and comply with the administrator regulations, but there is some flexibility in the legislation for an equivalent entity in a third country to be appointed as an administrator of an EIF. This would be subject to GFSC's consent and also ministerial approval. And the EIF regs also set out the bank broker provisions relating to EIFs. And again, there is some flexibility around who can be a bank and a broker of an EIF, which is at the GFSC's discretion. And this also contains the restrictions on promotion and a few other specific offenses relating to EIFs. So regulated individuals, like the architecture of the Act, I assume some of you may have heard some of this before, but I've tried to make it a bit specific to this sector. So Part 8 of the Act establishes the regulated individuals regime, so the approval of regulated functions. So just to explain a little bit in terms of the terminology, the relevant terminology in this part, regulated individual is someone who has been approved to perform a regulated function, which is defined as functions that have to be carried out subject to approval of the GFSC. There are a few types of regulated functions, and these are set out in Schedule 14 to the Act. There's a generic type, which includes directors, head of compliance, and MLROs. That applies to all sectors. And then there's sector-specific functions. Not all sectors have specific ones, but AIFMs and UCITS management companies, for example, do have. So in addition to the general functions, you have the head of investment, the head of account, valuations, the head of internal risk, and the head of risk management. That would need to be fulfilled by in-scope AIFMs and UCITS management companies. Small scheme managers, you should know that small scheme managers would not have to fulfill these additional specific functions. Then you have Schedule 15 of the Act, which sets out an additional regulated function, which contains some specific functions for some types of regulated firms, but these can be waived by the GFSC, or they may not be applicable depending on the type of activity or the nature or the size of the firm. So that's discretionary. And then finally, there's a significant influence function, which was a new one that was introduced via the LRP, which essentially includes someone who exercises a significant influence over a regulated firm. Either they perform the regulated function in the background, they are instructing others to perform that regulated function. So essentially someone who's behind the scenes that has quite a lot of influence over key decisions of the firm, but may have not necessarily been put forward as a regulated individual. Next slide, please. So very quickly, in terms of the approval criteria and the process, this was very much the same as it has always been. You have to be fit and proper. The GFSC takes you through to the approval process. Certain timelines in the legislation that need to be complied with. The types of approval, there's a provisional approval or conditional approval. So provisional approval is the equivalent of what the GFSC used to do before, which was approving subject to conditions. And the conditional approval is approval with more longer term conditions. So the provisional one is, I suspect, the one that GFSC will use going forward, which basically means that they can approve you on a provisional basis, subject to, for example, complying with or obtaining some specific qualifications, training, or working under the supervision of an existing director, for example, and subject to complying with those requirements, you would be fully approved after a certain period of time. Excuse me. The Act Part 8 also introduces the temporary concept of a temporary position. So in cases where for example, something happens to a particular individual and you can't be expected to replace that person immediately, there is some flexibility in the legislation for you to appoint someone temporarily. It could be someone who's carrying out another regulated function within the firm. And there were some transitional arrangements, which I suspect most of you have already worked with the GFSC in order to transition from the old regime into the new regime. Very quickly on sanctions, as I mentioned before, Part 11 of the Act sets out the sanctioning powers, fines, public statements, cease and desist order. So these are applicable to all. There are some additional sanctioning powers, particularly in relation to fines and limits, which would be covered in the sector-specific regulations. Next slide, please, Alan. Thank you. The Part 10 of the Act contains the information gathering and investigatory powers of the GFSC. There's the inspections and the skilled persons report. This is covered in this part. The power of the GFSC to carry out an on-site. In terms of the inspection, there were some changes to the costs and the cost order. The GFSC would now cover costs generally, and the DMC would consider whether or not they order a cost contribution order for the firm to pay back some of the costs depending on the outcome of the inspection. So these are a few other parts of the Act that will be relevant to all regulated firms. So there's Part 9, which deals with the control, so changes in control, whether there is an acquisition of a qualifying holding or decrease or increase or relinquishing a qualifying holding. This is a part that sets out the procedure, the application, and the process that the GFSC would go through when there is a change of control. Part 12 deals with the duties of auditors and actuaries as they apply to regulated firms, and the fact that the auditors and actuaries should have access to all relevant information, and firms should provide that information as necessary. Part 28 deals with the general notice procedure, and it covers appeals and the publication of actions of the GFSC. So I think that's relevant for everyone. And then there's some generic offenses. So the fact that you kind of provide misleading information to the GFSC, for example, is an offense. There's not that many, but that's covered in Part 30. And then there's a few other pieces of legislation that are relevant to funds: the European Long-Term Investment Fund regulations, the European Social Entrepreneurship Funds, and the European Venture Capital Funds. These all derive from EU regulations that were implemented in Gibraltar law a few years back, and they still are in the same form as they were before. Something will have to change in respect of these regulations as a result of Brexit, but at the moment there's been no change. And finally, there's the fees regulations that applies obviously to all firms. That's it on funds generally. Before I start on EU exit, does anyone have any questions? No? Good, I'll carry on. Okay, so just to give you an update on the changes that have been made as a result of EU exit. Most of our financial services legislation have very recently gone through a whole raft of changes, which came into force on the 1st of January 2021. There's still a few sets of regulations and a few other pieces of legislation that need to be amended. So some further changes will come through. But most of them have been done. So the main aim of the changes is to provide continuity in the law in a post-Brexit world. And the only changes that have been made are those that are absolutely necessary at this stage and required as a result of EU withdrawal. These changes would mainly affect incoming and outgoing passporting, which I know has been an issue that I'm guessing most of you that have passported out, for example, have been discussing with the GFSC, because obviously that falls away, and it shouldn't really affect local firms in other ways. What we've ended up with really is a domestic regime, which is the principal change, or the principal changes to our legislation is to make it a pure domestic regime, focusing on Gibraltar regulated firms and those businesses that are carried out from Gibraltar only. There has been a few changes, for example, in respect of market abuse, where activities may affect Gibraltar, the reputation of Gibraltar, or may affect the markets in Gibraltar and externally. So in that case, there is a bit of a wider scope, but there is a specific piece of legislation dealing with that. Some of the other changes, more specific changes that have been made, are to, for example, remove all the EU-related processes. So passporting provisions, any joint supervisory arrangements with EU authorities have been removed. So generally now EA states will be treated as any third country, so which is defined as any country or territory which is outside Gibraltar. We have also removed all references to EU institutions, European supervisory authorities, etc. There were reporting obligations to such entities which have either been removed or, if no longer relevant, removed if no longer relevant, or amended and referred to a domestic authority. So, for example, there could be a reporting obligation to the minister instead of an EU institution, or to the GFSC. Most of the cross references to directives have been replaced, removed, and where possible, replaced with a domestic reference, or if necessary, directive text has been copied into our legislation. The minister has also been granted powers in retained EU law to make regulations, delegated acts, or adopt any equivalence decisions, as well as the power to issue technical standards, which were issued before by European supervisory authorities. And in terms of alignment with the UK, so where appropriate, we have followed the UK approach in some cases. So for example, in the EIF regs, in relation to the bank broker provisions, whereas before it referred to, I think it was local, you could use a local bank or a local investment firm or an EA one. Now we've gone with the definition that the UK used, which is based around OECD states, rather than refer to specific EA institutions. And it's quite broad, and it would capture, I would imagine, all banks or brokers that have been used by EIFs to date, and will give flexibility, obviously, to be able to use other firms and not limited to Gibraltar banks or brokers only. This obviously reflects the close alignment that we have with the UK, and which already existed, and which will hopefully bring us closer together. So this is the final slide on EU exit. I'm going to talk very briefly about the temporary permissions regime and the transitional arrangements. So there's a piece of legislation called the Financial Services Passport Rights and Transitional Provisions EU Exit Regulations 2020, which came into force on the 1st of January this year. And this introduces a temporary permissions regime, amongst a few other things. This enables EA firms and funds to continue carrying out business in Gibraltar as if they were authorized, provided that they go through some a particular process with the GFSC. Either they apply for authorization or they notify the GFSC of their intention to do so, depending on the activity. These regs, they also provide for EA firms which do not want to continue doing business in Gibraltar, allowing them to wind down in an orderly manner, and they would also be able to honor existing contractual obligations. So they're able to continue carrying out regulated activities on a restricted basis where it is necessary to perform ongoing contracts. And those contracts would have had to be entered into before exit day. There's also provisions around temporary approval of the marketing of AIFs, EU serfs and EU VECAs, and deemed authorization provisions for EEAA firms where they were doing so before exit day. But obviously that is subject to a particular timeline. And I think it's after 3 years, they would have to stop doing so, unless or seek authorization in Gibraltar. In terms of Gibraltar and the UK, what these regs do is provide for the continuing of the market access between Gibraltar and the UK. So it maintains existing provisions, even though they've been omitted from legislation, it maintains those provisions for the purposes of passporting between Gibraltar and the UK. So there's a savings provisions in these regs to continue to apply such provisions, and there is a specific one for UK CISs. To continue to have that regime in place as well. So what's next? As I mentioned before, there's a few EU exit regs that are currently being worked on that still require some changes. But then there's also all the retained EU laws, so all the directly applicable regulations, MIFIR and CRR and a few others, which have been retained in Gibraltar law, but obviously there are deficiencies unless we go through the process of amending them and making sure that they work in Gibraltar and they can be read in Gibraltar law with the necessary modifications. So that is a process that at some point Gibraltar will have to go through. Some have already been dealt with, as I mentioned before. The market abuse provisions or market abuse, the EU market abuse regulation has been implemented specifically in Gibraltar law with the necessary changes. And when that's been done, we follow the UK approach to those changes. But there are quite a few that will need to be amended. For example, there needs to be changes to references to EU institutions, to anything relating to supervisory convergence across the EU, etc. So that's a piece of work that will need to be done. And in relation to Gibraltar and the UK, I've mentioned the current position, which is it's a transitional arrangement really, because there are, as most of you are probably aware, negotiations between Gibraltar and the UK in relation to the longer term access referred to as the Gibraltar authorization regime. That needs to be established in legislation, so there will be further changes to both Gibraltar and UK legislation to make sure that that is in place as soon as that transitional arrangement expires. So just to conclude, I think as a jurisdiction, we are in a very good position, as a small jurisdiction in particular, with quite a modern and up-to-date legislative framework. It's future-proof and it's capable of being adapted as necessary. So I think everything's been done to be able to look to the future in a post-Brexit world and see what other changes can be made. And that is it.
Great, thank you very much, Ernest. I'm not too sure whether you can hear me.
Yes.
Okay, perfect. Okay, good. I had my mic on mute whilst you were giving your presentation, but I found that, at least personally, I found that really interesting. I'm just going to quickly check to see, and I'm going to stop sharing the screen at this point in time, and I'm going to quickly check to see whether we have any Q&A coming through. And indeed, we do. And a first question from Julian is one that we sort of anticipated we may have this morning, which is whether there was any update on the proposed dual regime in respect of AFMD. At least I know I can certainly say, having the benefit of sitting on the GIFIA executive, this is something that we've been working very closely with the regulator on. We've made our views quite clear on you know, how crucial, how critical we as the business believe the dual regime to be for the jurisdiction post Brexit. But although we know a decision is imminent, there is none yet at this time. But we do expect to be able to be sharing news on that in the imminent future. And as a follow-up to that, we will undoubtedly be hosting a training on that as soon as an announcement is made by the regulator and by the government in conjunction. So I think the most we can say on that subject is keep your ears to the ground on this one. But it should be coming pretty soon, and I'm really sorry I can't be any clearer on that at this point in time. We also have a follow-up question from somebody asking the very same question on dual regime. So it just goes to show how much that is on the forefront of most people's mind in the business about having this. So I'm not too sure we have any other questions at this point in time. I do. So one for you, Ernest. In fact, I have a couple. The first one, I think it was around about slide 10 on your presentation. You were explaining the roles of regulated individuals, or at least what regulated individuals would deem necessary. I just wanted to clarify, or ask you to clarify for us rather, which roles are mandatory versus which roles are, you know, more desirable by the regulator, especially when it comes to sector-specific roles.
Yep. So the three general roles are mandatory for all sectors, and when it comes to sector-specific roles, they are also mandatory for those sectors. So where there's I think part 2 of that schedule where it lists the sector-specific functions, those are also mandatory. When there is some discretion is the other 2 roles that I saw. There's a significant influence one, and the other one where there's a list of other roles for particular entities. In that case, it doesn't really define the type of regulated activities more across. So companies, you would need to consider having a CFO, for example, even though it may not be sector specific, but it would be depending on the size of the firm, for example, and the nature of the activity of a particular firm. So yes, the general functions and the sector-specific ones are mandatory, and the other two types of regulated individuals are discretionary.
Perfect. Thank you very much for clarifying that. Another question I had was on more in relation to the EU exit, or i.e. Brexit, and in terms of the transitional period for which firms may continue to operate here in relation to EA business. How long do we know that transitional period is going to be extended for?
At the moment, if I remember correctly, that transitional period will be in place, and I think it depends on the activity, until the end of the year, but there is the ability to extend that transitional period. We expect that there will be firms who are obviously going to be ceasing doing activities in Gibraltar, so they'd go through that wind down process. I'm not sure how many firms actually will continue to operate in Gibraltar post-Brexit on the basis that they will need authorization, or as a minimum they will need to notify and comply with some requirements at least. So I don't know how beneficial it would be for firms to continue to do that. I don't know whether there's any stats, the GFSC has any stats on that, but I'm not aware. Okay, great.
I can't see any further questions coming through from our audience today, and I'm certainly out of questions for you. I'm conscious about the time, and I think it's been an extremely interesting session, very well laid out, and I thank you for helping us learn how to navigate the LRP going forward in terms of its different parts and sections to the Act. I think it's certainly going to help us to be able to get out the information that we need as regulated individuals or firms going forward. So thank you very much, Ernest, for that. We look forward to having you back as a panelist soon for another training session in the future, which I know we still have to pencil in for this year. So once again, thank you very much from all of us here at GIFIA. No problem. And just to wrap up for the audience, again, thank you for your attention. And just one final note to leave you on, we have another training that we are co-hosting with Gecko next Wednesday, which is a follow-up session to CRD5. And we'll be joined by a speaker from the UK, Caroline Dawson, who's been here in person in Gibraltar. Unfortunately, because of obviously travel restrictions that we're still suffering, she won't be able to join us physically. So it'll be once again a virtual seminar. So just as a reminder, there are places still left on that. So please feel free. I encourage you to sign up to that over the coming days so we can see each other again next Wednesday. Okay. Thank you all. At this point, I'll mark the end of the training session and look forward to seeing you soon. Okay. Bye-bye.
Bye.